We begin with George Zimmerman's day in court. Joyanne Reed is managing editor of Griot.com. She joins us right now. And Kendra Coffey is a former U.S. attorney. Well, I always start these conversations by saying I am not a lawyer. I listen to those who are. Let's take a look at this. Here's George Zimmerman speaking in court this morning and addressing the parents right there in court of Trayvon Martin. Let's watch.
I wanted to say I am sorry for the loss of your son. I did not know how old he was. I thought he was a little bit younger than I am, and I did not know if he was armed or not.
Joyanne Reed, that is something that the defendant in this case says he wanted to do earlier, but there he did it in court today. What do you make of it?
Well, you know what's interesting, Chris, is that the family of Trayvon Martin found that very off-putting and disingenuous. I mean, the truth of the matter is George Zimmerman has had opportunities to address the family before. He started a website a couple of weeks ago at which no such statements of contrition were included. He's also had a phone call. He left a message for a friend, Frank Taffy, in which he expressed no remorse. So when I spoke with one of the attorneys for the Martin parents, they simply felt that this was a performance for the cameras, that this was about humanizing George Zimmerman.
Yes, but what did he say was the reason he did it today? Well, I understood his statement was that he had tried, he was told by counsel not to try to contact the family. Isn't that the case?
Well, that is what he is saying now. But again, we only heard for the first time that he wanted. The family has essentially said that they've had no contact from George Zimmerman.
Well, we know that, but was he told by his attorney? Let's go over to Mr. Coffey. Would it be normal for an attorney to tell a defendant or potential defendant in this case not to contact the victim?
Of course it would be, and it would be not very common to put a defendant on the stand for any reason whatsoever to make what was an unwanted and apparently unappreciated apology, because it creates the risk that the prosecutor might be able to go somewhere when you expose your client to cross-examination. Now, the judge kept a very short rein on the prosecutor, so it didn't blow up in defense's face, but it was an unnecessary risk, and it certainly doesn't seem to have accomplished anything for George Zimmerman.
By the way, I'm not a lawyer again, but I'm always surprised by things that happen in court. Let me ask you this, Mr. Coffey. Is it normal for a prosecutor in a bond hearing to just say to the person, the defendant in this case, you committed a crime, that day you committed a crime, to basically say he's guilty and act as if he's been found guilty? Is that normal parlance, acceptable parlance in a courtroom?
Well, I guess if you can get away with it, it seems like a clever move.
Did it surprise you he could get away with it?
It surprised me that the defense didn't object. At the end of the day, it didn't turn out to be a big deal. But yeah, he said when you were committing that crime, I thought it would prompt an objection from somebody. But again, at the end of the day, important result for George Zimmerman. He is going to be out on bail. Joyanne, were you surprised by that? That he just called him a convicted criminal, basically? Well, he said you committed a crime, just right there in court, as a fact.
And he really also challenged him very much. So, yeah, I think that the presentation of the prosecution was as much as he could to try to cross-examine George Zimmerman. But as Kendall Coffey just said, there was a very tight rein on him. The other thing that was interesting—
Wait a minute. He didn't cross-examine. He said you are a criminal. You committed a crime that day in his questioning. He just said it.
Right. I mean, but the idea is, of course, the presumption from the prosecution is that he is a criminal. That is the presumption they're going into this case with. So it's not shocking that they would present the case that way, because remember, the defense was trying to mitigate at every turn what was in that proffer from prosecutors. They were trying to say the word confrontation was problematic. It should have been met, that Zimmerman met Trayvon Martin rather than confronted him.
Isn't it?
So given
isn't confrontation a loaded term?
Well, absolutely, but it's also what the prosecution is trying to accomplish. They're trying to prove second-degree murder, so each side wants to present that evidence in their best light.
Well, let's take a look at further here. Here's video further. He said he didn't change his story. Here he is just denying that he's been giving conflicting accounts. Here's Zimmerman again on the stand.
And isn't it true that in some of those statements, when you were confronted about your inconsistencies, you started saying, I don't remember?
Outside the scope of direct examination, I would object, Your Honor.
Give him a little bit of leeway, not a whole lot, but a little bit here, okay?
Isn't it true that when you were questioned and you were questioned about the contradictions in your statements, that the police didn't believe it, you would say, I don't remember?
I'm going to grant his motion this time.
Thank you, Your Honor.
Would you agree that you changed your story as it went along?
Absolutely not.
Mr. Coffey, Kendall, let me ask you this question. Is this the normal thing with a bond hearing, that you try to establish the credibility of a witness? credibility of a defendant, I guess.
Well, what the prosecutor was doing was trying to take that little bit of an opening he had and be as aggressive as he could with George Zimmerman. By the way, he was also aggressive cross-examining George Zimmerman's wife and father, where they were very careful about holding back was their best evidence. And anybody that thinks that the best evidence that the prosecution has was fully displayed today is making the wrong takeaway from this hearing.
Your thought, Joanne?
No,
Joanne,
I think
I'm sorry.
No, that's fine. And I think that's true. I think the prosecutor actually said right at the end of his presentation, look, we've got a lot more. And you've got to presume that they were trying not to show too much of their case, because remember, there can be a second hearing, and Kendall Coffey is the expert that can explain that. There could be a hearing specifically on Stand Your Ground. They don't want to give the defense attorneys a preview of their case, which would give them an advantage going into that next hearing.
Let's take a look at this hot stuff. Here's George Zimmerman's father, who was questioned via speakerphone this morning. He was asked about his son's appearance following the shooting that night. Let's listen to his case, his testimony, at least right today.
So what did George's head look like when you saw it the day after?
Well, his face was swollen quite a bit. He had a protective cover over his nose. His lip was swollen and cut. And there were two vertical gashes on the back of his head.
Have you seen any pictures of that?
I did not take any pictures.
Have you seen any of them?
Yes, I have.
Who showed them to you?
I saw one on the news today.
Did state attorney's office ever show you any of those pictures?
No, they did not.
Well, let's take a look at the pictures. They're an exclusive. We got them from ABC News. Let's take a look at those pictures. There it is. I guess there is that gash there, two vertical gashes on the back of his head. I don't know how to read injuries. Joyanne, your thoughts about this evidence now that's all over the country now?
Yeah, you know what, Chris, when I saw that picture, the question I had is, when was that taken? Because if you look at the timeline as presented by the police report, George Zimmerman, within minutes of this shooting, was confronted by police officers. I spoke with EMS officials in Sanford, Florida, who said that Florida law would have prohibited them from taking any pictures if a neighbor walked onto this crime scene shortly after the shooting, but before Zimmerman was treated. Remember, he was treated in the back of a patrol car for cuts and bleeding nose. When did a non-member of the investigative team get to take a picture of the back of his head? That's the question it raised for me.
You're suggesting that the ABC account is inaccurate?
No, I'm just wondering who could have taken that picture.
Well, what are you saying? Because if you're saying that, you're saying it's not a picture of him that night.
No, I'm saying did other people get to come onto that crime scene? Did they take that at the scene? So, which would also raise questions about the investigation. If people not directly involved in the investigation were close enough to the crime scene or were on the scene before he was treated, that means that they encountered George Zimmerman while the police were still investigating.
And
so
why is that relevant? Why is that relevant to his guilt or innocence or his whatever happened that night?
I don't think it's relevant to that. I think it goes to the way that Sanford police handled this case, which has been sharply criticized, not just by Trayvon Martin's family, but by people I know in law enforcement who say, was this crime scene thoroughly checked, or did they just presume he was the victim and then not do the thorough investigation?
I think you're making part of a broader question about the whole way they dealt with this. And to me personally, watching this, again, with the presumption of innocence, I don't like the way the whole matter of this guy, this kid, the way he was treated that night and how almost irrelevantly he was treated, as almost like they assumed he was the bad guy. O'Mara, by the way, Mike O'Mara, who's the defense attorney here, questioned the investigator from the state's attorney's office as to who started the fight. Boy, this is a critical question between Zimmerman and Martin. Let's watch this interplay.
Do you know who started the fight?
Do I know?
Right.
No.
Do you have any evidence that supports who may have started the fight?
No.
You know, let me go to Mr. Coffey or Kendall. This is so, there's a number of steps in this. When did the encounter begin? We can assume the encounter began because he was trailing this guy. He was suspicious of him, whatever. You can throw in the profiling thing if you want, but he was suspicious of him. They confronted each other at some point. Does it matter under the law of self-defense who throws the first punch? Does that matter?
Well, it certainly can, and that's why I was, frankly, surprised by the gap in that part of the testimony. But certainly the state's going to get to work on fixing that, because if, in fact, it develops that Trayvon Martin started the fight, or that the state can't prove who started the fight. And I'm not saying by any means that he did. That's a problem. It certainly helps George Zimmerman with his self-defense, but we're very early on in this case. Again, we've got to emphasize the prosecution's got a lot more ammunition, and that is, as was being said a moment ago, something that they've got to save up for the stand your ground hearing, because if there is such a hearing, it gives the judge the ability to throw this whole case out, and that's going to be a much more actively contested hearing than anything we saw today.
Well, the prosecutor, Bernie D. LaRonda, had one final message in his press conference. Let's watch that today.
You all have not heard all the evidence. Please be patient and wait for the trial. Thank you very much.
Well, this is so tricky here, Joyanne, and I don't know how we're going to cover this. I'm going to try to do it with a presumption of innocence here, as we do in all cases. I think everybody's going to be watching this with all kinds of attitude, however, right?
Yeah, absolutely. And, Chris, the bottom line here is that this case has already been litigated and relitigated on Twitter, online, on blogs. Everyone feels that they, too, are prosecuting this case, and people have taken a side. And I think that raises a lot of troubling questions, really, about jury selection. Is the entire jury pool in the country tainted? And can Zimmerman get a fair trial? I think those are all important questions.
What scares me, if we could all watch a picture, like a movie, a tape of everything that happened that night, from the beginning to the end, I think there would be a difference of attitude about guilt and innocence. That's what scares me about this case. There's so many different perspectives, so much history. Ever since the first slave arrived in the United States, the attitude of history here, you can't push it aside, I don't think. Anyway, thank you, Joyanne Reed, for joining us tonight. As always, please come back many times. Kendall Coffee to you, sir, as well. Coming up, Florida led the country with its Stand Your Ground law. It's maybe at the heart of this case, we don't know. After the Trayvon Martin's death, could it be the first in the country to repeal that law? That's ahead, and it's coming here in a minute. This is Hardball.